Okay, so the second opinion to talk about today is the social media case. What is the background?
Yeah, this is deeply concerning. Of course, your listeners are well schooled. They know that. Of course, you'd have to be hiding under a rock, but our listeners are particularly well versed in this social media censorship. That people come out saying, hey, I've got concerns about COVID. Hey, there's evidence this might have come from a lab in Wuhan. All of these things. I have concern that maybe these vaccines aren't the 100% effective cure that everyone promised. When people would come up on that sort of stuff, including like medical scientists and stuff, all of a sudden, Facebook and the former Twitter, now X under new management, but the former Twitter and Facebook would totally shut them down. And, disinformation, ring the buzzer, not shut all that down. Of course, all the stuff that everyone now knows was true, everyone talks about now, et cetera. And so the issue was, you had this social media censorship going on. Then you also have a doctrine from the Supreme Court Norwood case and other cases, because private companies don't need to follow the First Amendment. That gives you a right against the government, not against, private companies. However, there's a Supreme Court doctrine out there, starting with cases like one called Norwood from the 70s, that say that the government cannot do through using a private corporation what the Constitution doesn't allow it to do directly. And so if you get the federal government able to co-opt a company, they cannot coerce that company into violating the First Amendment, for example. And that's what they say was going on here. The case laid out all of these communications between the White House and Facebook and other social media companies, and all of this stuff where the White House is like, yeah, we don't like this guy. We want you to block him. Hey, we're real concerned that you're letting this topic be shared on your platform. If you know what's good for you, we're going to be very disappointed and are going to have to explore other options unless you, quote unquote, voluntarily decide to just shut this guy down. Now do what you're told. So you get all of these veiled threats. And the social media companies, which, they're left wing, and you figure that, and they want to do it anyways, or at least you figure that's the case. They engage in this censorship. And so you had two sovereign states, and you had some of these medical scientists, and you had someone who was an activist, an influencer online, all of whom sued and said this is a violation of the First Amendment. Very concerning. Because I think this is just dead wrong. I think that this isn't just wrong; it's wrong-headed. I'm actually concerned. Is that the Supreme Court, again by a divided court, it's said that these plaintiffs lacked standing to bring the lawsuit. Standing is something that Article 3 of the Constitution requires. In order to be able to, for a federal court to be able to use its power to actually render a decision. Standing, just three quick elements. A plaintiff has to have suffered an injury. It has to be traceable to the defendant you're suing. And the court you're bringing it in must have the ability to fix your injury, or redress is the fancy term, your injury, if the court grants the requested relief. So injury, traceability, redressability. And Justice Amy Coney Barrett wrote for a divided court saying that there is no standing here. And I think that's dead wrong. I think it's wrong for the reason. Yeah, go ahead.
Yeah, which of the three things did she think these people who were kicked off social media did not?
She's mainly going with traceability and redressability, where she's saying, this is really the private party here. These are these private companies, and then she goes on to say, and you need to prove. So she touches on traceability, and then she really lays down her chips down on the table on redressability, where she says, and you know what, for redressability, you have to show it's like, and she was essentially saying certain, which has never been the case. It's always just been likely. You have to really show us, and you don't go far enough to show that something like this is going to happen in the future, because you're not suing for money. You're not suing for damages. You're just suing for a court order that would apply in the future. And she says, you guys just haven't made a showing of how an order we could give today is going to help you in the future. Then you get a dissent coming, again, written by Alito. So, Alito really had a day yesterday. I think this is really an outstanding opinion written by Alito. It's just marvelous, where he just totally deconstructs the majority, explaining how essentially you and I talked about NRA versus VULO a few weeks ago, and he says this is just like VULO, except they were ham-handed, or ham-fisted is the term he uses for New York, which is just a euphemistic way of saying moron or idiot. He said they were stupid about how they did it in New York. They were just thugs. They were so on the nose with the threats they were making, saying stop doing business with the NRA or we're going to crush you. He said the lesson from today is this: be more sophisticated about it. Go through more levels. Do a better job of covering your tracks while you're making your threats to these private companies that they better carry out your agenda to violate the First Amendment. And he says, and if you do that, this court will give you a pass. And he said that is not the message that we should be sending. He said the principles that led us to strike down what was happening in New York in VULO, it's going on in a more sophisticated form with Facebook and the former Twitter, and the plaintiff showed all that, and this can happen again. So this satisfies redressability. It's these people these companies could do this again at the behest of the federal government, and so we should declare that it violates the free speech clause of the Constitution and shut it down forever.
Wow.
And they didn't. It's concerning.
Can the redressability, that last step, do you have to prove that this could happen again to me? Or could it happen again to people like me?
Great question. It has to be to me, because you can't assert, with rare exceptions, you cannot assert the rights of a non-party, of a third party. There are certain very narrow exceptions, like parents. A child cannot litigate on their own, so a parent can assert the rights of their child in court. But it has to be like that kind of a special, close, intimate relationship. So you can't say, well, someone else's free speech could be violated in the future. But the thing is, he's talking about the online presence of like this one healthcare activist as an example, where he's saying, they've made a sufficient showing that that there's a very realistic risk that this could happen again. You don't need to show that it's certain. It's just the other side. It just needs to be that, is this a live issue? Is this pure speculation, or do you have some basis for being concerned that you could get censored in the future? And then he says, and there's an extensive factual record that the trial court put together here showing that standard is easily met here, that social media censorship goes on rampantly. And given the hot button issues that these plaintiffs are engaged with, not just COVID, but also election issues. And guess what? In case you haven't noticed, we're in the middle of a presidential election right now. And so he's like, given all the stuff regarding which these people or the states had previously had their content demoted on or suppressed on, he says this is a very realistic risk that it could happen right now or at some point in the future, and so we still have jurisdiction. He said, basically, Justice Alito said that the majority was ducking the issue, and that, again, that's a real concern, because rights like free speech, that's where we really have to rely on the courts, because it's that goes to the center, and he really waxes eloquent on it, how it's at the heart of an enlightened democracy for citizens being able to say what they think and believe and share it with their fellow citizens to get them to consider an issue, especially as you're going into the ballot box. And so he really goes to first principles in the Constitution on this issue. There's some just wonderful, wonderful quotes in there, like just this one where he says, freedom of speech serves many valuable purposes, but its most important role is protection of speech that is essential to democratic self-government and speech that advances humanity's store of knowledge, thought, and expression in fields such as science, medicine, history, the social sciences, philosophy, and the arts. And so, I mean, he really lays out what's at stake when it comes to the First Amendment and the importance of courts upholding the rights of all of our listeners. Whether people agree or disagree on an issue, their right to speak, free of the government silencing them.
Yeah, that's essential. That's it should be the First Amendment of all of them. He makes the point that if a president dislikes a newspaper, he fortunately cannot just put that newspaper out of business. But with Facebook, he says the Facebook social media companies are critically dependent on the protection from the Communications Decency Act of 1996, which shields them from civil liability for the content they spread. Zuckerberg described a potential antitrust lawsuit as an existential threat to the company. So the federal government has total leverage over these social media companies. Says you must do what we say or else. The social media companies have to abide, otherwise they can be destroyed. Yet they didn't. Here's this line. The court, however, shirks that duty and thus permits the successful campaign of coercion, in this case, to stand as an attractive model for future officials who want to control what the people say, hear, and think. Wow, that's a problem.
That's right.
Okay, we'll talk more about that one. Any other case here, Ken?
Well, I'll tell you that was yesterday, but guess what? The Supreme Court will sit again at 10 a.m. today, and then it will sit again at 10 a.m. tomorrow. Tomorrow might be the last day. We won't know until tomorrow if they hand down the final decisions. But, I mean, they have about a dozen decisions to come down, and that is a manageable caseload for today and yesterday, so we could just have all history will be made in the next few days with the cases we've discussed on previous shows. Today and tomorrow are going to be huge for the rule of law in the United States. So we can talk about those decisions as they come down.
I'm so grateful we can. The Trump immunity case, would they release that today before the debate? Or would they wait on that?
Well, first of all, I don't think they'll time it one way or the other for the debate. I think it'll come down when it comes down, and they're not going to let politics get in the way of it, despite some warning signs that we got, again, from Justice Alito over the past 24 hours. I'm personally expecting it tomorrow, but, I'm not. But if I were a betting man, I wouldn't put any money on that because they can hand it down whenever it's ready. Given that it was the final case argued, I would not be surprised if it comes down the final day. So I'm expecting it tomorrow. But I'll tell you, Mike, we might have cases today and tomorrow, and then they don't hand it down as they're reading opinions tomorrow, and then the chief gives an announcement after they've read their decision saying they're going to hold one more session on Monday, and that's when they're going to hand down the remainder. So I would say sometime, probably today or tomorrow, but it might be Monday when we're going to get the Trump immunity case. I don't think it goes any later than that. Of course, having said that, maybe they'll do it Tuesday now that I've put myself out there.